This video is about defamation and privacy. The first segment, about 16 minutes long, focuses on defamation, and the last 13 minutes focus on the 4 privacy torts. Thank you. It was about defamation. Defamation is the intersection of torts and constitutional law. On the bar in essays, it tends to be tested as a torts topic. What is defamation? Defamation is a claim for injury to reputation. There are 2 types of defamation, libel and slander. Libel is written, slander is spoken. Take a look at these. Which is slander? C is slander. Yelling across a crowded theater or talking to someone is slander. In contrast, writing a letter or an email is libel. Option D, a television show. Although people speak on a television show, courts treat television and radio as libel. We only care if a statement is libel or slander when we get to the topic of damages. However, the bar examiners prefer you to identify it as libel or slander at the beginning of your essay. Let's look at the elements of defamation. There are 5 elements. 2 are traditional. The last 3 are mandated by the First Amendment and depend on the type of plaintiff. Let's look at the first element. There must be a defamatory statement. That means a communication that tends to harm the plaintiff's reputation. Courts say it lowers him in the estimation of the community or in a substantial and respectable minority of the community. Let's look at an example. Suppose a newspaper reports that Tony Soprano is cooperating with law enforcement authorities. This is not defamatory. It doesn't lower his reputation in the community. He might argue that his friends think less of him, but look at the test. It has to be a respectable minority, so his friends, mafia people, do not count. The second thing the first element requires is that the statement be about the plaintiff. We use a reasonable reader test to ask if the reasonable reader would realize it was referring to the plaintiff. The plaintiff can introduce evidence to try and convince the jury that the statement is about them. The problem you'll see here is group libel. For instance, if the communication was that all doctors in America malpractice regularly, no individual doctor could sue. Why? Because the statement is not about any individual doctor, but them as a group. In contrast, if the statement was the 11 doctors who practice in Doctors R Us all malpractice, any one of them can sue, because 11 is a small enough group that we would say it referred to each one of them individually and hurt each one of their reputations. So defamation, first element, defamatory statement about the plaintiff. Second element, publication to a third person. This requires the defendant to have intentionally or negligently communicated the statement to at least one other person, not just to the plaintiff. Repeating something counts as publication. Let's look at a couple of hypos. Suppose Kate writes a letter to her fellow lawyer stating that the lawyer takes bribes. She simply mails the letter straight to plaintiff lawyer. Plaintiff lawyer cannot sue for defamation. Why? It wasn't communicated to a third person, only to the plaintiff. No claim of defamation. In contrast, if the defendant dictated the letter to her secretary, now her secretary has heard the contents of the defamatory statement so that the plaintiff lawyer can sue for libel. The communication was communicated to a third person, the secretary. If the secretary then goes to lunch and repeats it to his friend Rose, then he has published, even if he's just repeating. Guess what happened to work today? Guess what lawyer said? By repeating, he publishes and becomes liable for defamation. So that's the element of publication. Let's look at falsity. What do we mean by falsity? Falsity means there's a communication of a false fact, not the truth that causes harm. So for instance, if a Bar Association newsletter says lawyer L is dying of cancer, if it's true, Even if the lawyer has striven to keep it confidential because it's going to hurt his ability to get clients, this cannot be defamation. It might be intentional infliction of emotional distress. It might be interference with a business relationship, but because it's true, even if it's harmful, it cannot be defamation. The falsity element is not met. The other requirement of falsity is it cannot be a pure statement of opinion. That's not a false statement of fact. However, the court has ruled you can't play tricks disguising a factual statement as opinion. So for instance, if you say, in my opinion, Gilles takes bribes, the court would treat this as a false factual statement and ignore the fact you try to coat it with a layer of opinion. Name calling is almost always treated as opinion. Equally, one of the important impacts of this requirement of falsity is that sports commentators, restaurant critics, movie reviews, and editorials are generally treated as not actionable for defamation because they are statements of opinion, not provably false facts. Let's do an example. Suppose plaintiff Dr. Paul is a physician, his patient Dan is upset, so Dan sends flyers to all of Dr. Paul's patients. Suppose the first flyer says Paul is a rotten doctor. This is an opinion. It's not actionable because it's not provably false. In contrast, if the poster said Paul is a rotten doctor, he isn't even licensed, do you see if this statement has a false factual connotation and could be the subject of a libel action? Who has to prove falsity? The Constitution requires certain plaintiffs to prove falsity. Which one? Public plaintiffs, i.e. public officials, public figures, have to prove falsity. Equally, a private plaintiff, if they're suing on a matter of public importance, also has to prove falsity. It is not constitutionally required that a private plaintiff, if they're suing about a private matter, for instance, what time they got home at night, what they ate for lunch, they do not constitutionally have to prove falsity. So we've looked at the first three elements. Now let's look at the tough element of fault. You should realize that the First Amendment requires different plaintiffs to prove different levels of fault. Let's look at the three levels of fault. The highest level of proof is called actual malice. This means the speaker, the defendant, knows their statement is false or is reckless, doesn't care whether it's true or false, and yet goes ahead and makes it. The next step down is simply negligence. There's a lack of reasonable care by the defendant as to whether the statement is true or false. They don't investigate, they don't have any research, they simply make the statement. Lack of reasonable care. Finally, some states historically allowed no fault liability, where the defendant was liable even if they took reasonable care. Let's try an example just to make sure you can see how the levels of fault are differently. So defendant Dan writes in the local newsletter that Brett was arrested. In fact, it was Colin who was arrested. So is it actual malice if when Dan writes the newsletter, he knows it was Colin, not Brett, and yet states in the newsletter it was Brett? And the answer is yes. This is actual malice because Dan knew what he was writing was false. In contrast, suppose Dan saw the arrest, thought it looked like Brett, and didn't bother to check the police report that said, no, it was actually Colin who was arrested. B is a lack of reasonable care. It's negligence, but it is not actual malice. As you can tell, actual malice is an extremely hard standard to meet. You have to show the defendant knew it was false or was reckless as to its truth or falsity. Who has to prove what levels of fault? Public plaintiffs, whether public officials or public figures, have to prove actual malice. In contrast, private plaintiffs, when they're writing about a public issue or matter of public concern, only have to prove negligence. Let's see if you can tell the difference between these types of plaintiffs. So this is Governor Kasich. What type of plaintiff would he be? Hopefully you recognize that he is a public official. Why? Public officials are defined by people who hold government jobs, but also they have to have a high level of responsibility so that the public has an interest in their exercising their governmental powers. So Governor Kasich is easily a public official. What does that mean he would have to prove? He would have to prove actual malice, that the author of the story knew it was false or had reckless disregard as to its truth or falsity. Let's take a different example. LeBron James. What kind of plaintiff would he be? A court would likely designate him an all-purpose public figure. That means he has such pervasive power and influence in society that everybody would recognize him. And all-purpose means that we treat him as a public figure no matter what story is written about him. So a story about drunk driving, he's a public figure. A story about buying a house, he's a public figure. A story about playing basketball. An all-purpose public figure is a public figure for everything you could write about them. And they're usually highly famous people. What do they have to prove? They're over here, right? All-purpose public figures have to prove actual malice, that high standard of fault. Let's take a tougher example, one the bar examiners like playing with. So suppose you're a private defense attorney and you take on a high-profile criminal case. Obviously, you're not a public official, you're not a government employee. You're not all-purpose public figure. Someone like Johnny Cochran would be. If they appear on the TV all the time, they might be an all-purpose public figure. So the issue here is whether you're a limited purpose public figure, in other words, you're a public figure for the purposes of this high-profile case, or whether as a lawyer you simply remain as a private figure. Here's the test. The question is whether you thrust yourself into the debate, whether you voluntarily engage in the discussion. So, if you walk out of the courtroom and start giving statements to the media about your case, the court is going to say you're a limited purpose public figure. However, if you walk out of the courtroom and say no comment, simply because you're acting as a lawyer in a high-profile criminal case, you will remain a private figure. The court focuses on whether you voluntarily engage in the debate. Why does it matter which you are? Remember, if you're a public figure, even a limited purpose public figure, you're going to have to prove actual malice for any stories about the criminal case, the issue for which you're a public figure. In contrast, if you don't talk to the media, you're going to be a private figure on a public issue. And to recover, you would only have to prove negligence. So watch out and see if someone's a private figure on a public issue. The court tends to push people down to private figures on public issues. So if you're unsure, lean towards classifying them as a private plaintiff on a public issue or a private plaintiff on a private issue. The last element we have to look at is the appropriate proof of damages. And this is where you have to watch out whether you have slander or libel. Here's the common law slander rule. The rule for slander is the plaintiff could only recover for slander if they proved special damages. Special damages is another way of saying economic loss. In other words, you lost clients, you lost business, you were fired. So for the traditional rule is to recover for slander, you must prove economic loss. There are four statements, right? 4 types of slander, which if made, trigger presumed damages. These are often called slander per se. If you say someone's committed a serious crime, unchastity of a woman, loathsome diseases, or a statement which injures someone in their trade, business, or profession, these 4 types of slander, slander per se, get presumed damages. Otherwise, you have to prove economic loss to recover for slander. In contrast, in libel law, we presume damages. At common law, You just had to prove to the jury the false defamatory statement about you, and the jury could presume you were injured and just pick a sum of money. Equally, the jury could often simply award punitive damages on a showing of some kind of recklessness. The Supreme Court has limited the ability to collect presumed and punitive damages. Here are the limits. If it's a public plaintiff and they've already proven actual malice, the court has said because you've proven such wrongdoing, then you can get presumed and punitive damages. In contrast, if all you've proven is negligence, right here, you're a private plaintiff, public issue, you just prove negligence, the court says you also have to prove actual damages. Or, as a private plaintiff on a public issue, you could elect to prove actual malice. If you elect to prove this higher level of fault, actual malice, you're going to get these presumed and punitive damages. A private plaintiff on a private issue is allowed to recover presumed and punitive damages without any special burden of proof. Okay, so the impact of this presumed and punitive damages rule is typically triggered private plaintiff, public issue, because if they want that type of damages, they have to up the level of fault they prove. Finally, let's take a look at defenses. Truth is always a defense. So if the plaintiff was not required to prove falsity, the defendant can always raise the truth of their statement as an absolute defense. In addition, there are two defenses, absolute privilege and qualified privilege. Absolute privilege means there's no liability. It doesn't matter if you made the statement with a bad motive, if you abused your privilege. If it's absolute, you can't be liable. So who gets absolute privileges? Legislatures in Congress or state legislatures on the floor of the legislature. Executives, high-level executives get absolute privilege when they're performing the governmental function, making a press release or a statement as part of their executive function. Lower-level executives will only get qualified. And then judges, and then anyone involved in a judicial hearing, a lawyer, a witness, statements and pleadings, as long as they're relevant to the case, will pick up absolute privilege. In contrast, qualified privilege. Qualified means if you abuse it or use it with a wrong motive, you lose it. Qualified privilege is triggered when you have a duty to communicate to someone else. Typical examples could be letters of reference. You have a qualified privilege if you say nasty things about someone in a letter of reference. Equally, confidential information of mutual interest of the speaker and the recipient, like class evaluations, or reporting a crime or wrong to the appropriate authority, will pick up a qualified privilege. So, hopefully this will help you understand defamation and all the defenses. Enjoy. This is Professor Susan Gilles, and this part of the video is about privacy torts. They're often tested along with defamation. There are, in fact, 4 privacy torts, and the key is to compare and contrast these torts. Let's start with intrusion upon seclusion. The elements of this tort are one who intentionally intrudes, physically or otherwise, upon the seclusion or private affairs of the plaintiff in a way that would be highly offensive to a reasonable person. The focus is on the invasion or intrusion into seclusion. It does not require publicity. Examples would be if the defendant wandered up to your house, looked through the window, and observed what you did all day. They intentionally intrude upon private affairs. You have a reasonable expectation of privacy in your house, so this third element would be met. In addition, it would be highly offensive. Other examples include simply using a telephoto lens to spy on you inside your house or in your backyard, anywhere you have a reasonable expectation of privacy. It would also be met if the defendant rifled through your mail or hacked into your computer and looked at private, confidential, financial, and medical files. Anywhere you have a reasonable expectation of privacy, the invasion of those private affairs constitutes the tort of intrusion upon seclusion. An example would be if Alison is hospitalized and Bob the reporter calls, asks for an interview. When she refuses, he shows up in her room and then takes her photograph and then publishes it in the newspaper. When he first makes the call, this would not constitute intrusion. Although she might have a reasonable expectation of privacy, it has to be highly offensive to a reasonable person, and one call would not be highly offensive. In contrast, if he called her 20 times night and day, that call by itself would be intrusion into seclusion and justify a tort remedy. Obviously, when he enters her hospital room, she has a reasonable expectation of privacy and the tort is committed. When he takes her photo, again, it's intrusion into her private affairs and she has another tort claim. Notice, however, that when he publishes her picture in the newspaper, this is not the tort of intrusion, because this tort is not about giving publicity. Now let's look at the next tort. The next tort is called appropriation. One who appropriates for their own use or benefit the name or likeness of the plaintiff. This is a relatively simple tort. The key is that it focuses not on private information, but really on a property right claim. If you're using someone else's name or likeness, you have to get their permission and/or pay them. Some states hold that the defendant must benefit economically from the use of the name, where other states hold the tort is completed if the defendant has any benefit from the appropriation of name or likeness of another. These cases typically feature a movie star or some celebrity whose name or likeness is used to endorse a product without their permission. For instance, if you put her image on your diet supplement, that would be appropriation. Now let's look at the third privacy tort, publicity to private facts. We'll go through this a little slower, looking at each element. The focus of this tort is that your claim is the defendant is giving publicity to true private facts, facts about your private life. First, publicity is a key term. Publicity means relating to the public generally, or to a large enough group that you're substantially certain it will become public. So it means distributing it to the public, publicity. A newspaper would constitute publicity. Equally, putting something in a company newsletter would be publicity. However, gossip, telling one or two other people, would not meet this publicity element. Now let's look at the next element. It has to be publicity about a private fact, about your private life. Things that appear in public records are not private facts. They cannot meet this element. So for instance, anything in a court record, records of birth, death, marriages, house purchases, anything in a public record is not a matter concerning your private life. Either anything open to the public eye. So if you kiss someone at a ballpark, you cannot claim private fact because it's open to the public eye. What is enough to meet the second element? Typically, the courts will hold that confidential information about sex or your family, your medical records, your financial records, all constitute matters of private facts or private lives, and if the defendant gives publicity to them, you can sue under this tort. A public person can use this tort. However, courts tend to say they have a lesser expectation of privacy, a smaller group of information which we would deem to be truly private. You also need to show that the matter publicized would be highly offensive to a reasonable person and is not of legitimate concern to the public. This last factor is a huge exception demanded by the First Amendment. Anything that's newsworthy cannot be the subject of the publicity of private facts tort. So for instance, a story about a politician's family life, because the public has legitimate concern, it cannot be the subject of the private facts tort. Or a murder, even if it reveals what would be otherwise private information, cannot be the subject of this tort because it's newsworthy. Remember our example about Alison in the hospital? Now you should realize that when the defendant reporter publishes the picture he took in the newspaper, This is the publicity. You'd have a claim for giving publicity to private facts. One important feature is to differentiate publicity to private facts from defamation. Here's how. First, notice the difference in the communication requirement. Defamation only requires communication to one third person or more, so gossip is caught up in defamation. In contrast, publicity for the private facts tort requires communication to the public at large. Mere gossip will not give you the private facts tort. The injury they seek to remedy is also different. Reputation seeks to remedy injury to the plaintiff's reputation from the publication of false facts. In contrast, the private facts tort seeks to remedy the harm to their privacy which is caused by giving publicity to true private facts. Now let's look at the fourth and final privacy tort, false light. The elements all focus on false light. So let's have a look. 1. Publicity. This is the same requirement we saw in the publicity of private facts tort. Secondly, you must place the plaintiff in a false light. What does that mean? An example would be if you wrote a story about someone's military service and you falsely stated they'd won a Medal of Honor. It places them in the public eye in a false way. They are made to appear other than they are, so you would have a false light claim. Once again, it has to be highly offensive to a reasonable person. And the fourth requirement is actually an actual malice requirement. The key to it is giving publicity, which creates a false image about the plaintiff. Let's compare it to defamation, because they are very similar. First, remember the publication distinction. You can have defamation where there is publication, technical term, communication to one third person or more. In contrast, for the false light tort, all the privacy torts that have a publicity requirement require communication to the public at large. Secondly, while the injuries between the two torts, false light and defamation, are very similar, there is a distinction. Defamation asks whether the false facts hurt your reputation, that they lower you in the estimation of the community. That's not required for false light. False light also focuses on false facts, but simply asks, do they make you look other than you are in a way that would be offensive to a reasonable person? You don't need to show your reputation is lowered for false light. You just need to show you're made to look other than you are. Let's illustrate it. So a lot of behavior is both defamation and false light, but some behavior will only qualify as one versus the other. So let's take our first example. Suppose the newspaper reports that you are dating Brad Pitt. It's false. However, it doesn't lower your reputation, so it's not defamation. It simply makes you appear other than you are, so that would only be a false light claim. Let's try something that would only be a defamation claim. Suppose the defendant tells his friend that you are bribing a judge. False factual statement, lowering your reputation, but because it's only gossip, they're only communicating to one other person, you can't meet the requirement of publicity that's embedded in false light. So this would only be defamation. Many claims are both. So for instance, if there's a newspaper report that you were a robber, that would constitute both a false light claim and it would constitute a defamation claim. Or there's a TV report saying that you as a dentist malpracticed on a kid when that was a false statement. You'd both have a false light claim made to appear other than you are and a defamation claim that your image had been lowered. So at this point, I want to just make sure you can compare and contrast the different privacy torts, because this is how the bar tests them. They'll have a series of fact patterns which trigger all the different privacy torts. So here's the first one. Defendant uses my photograph in an advertisement for his new torts review videotape without getting my permission. Which tort is it? Of course, this is appropriation. Remember, the focus is on my property right in my name and image and my right to benefit from it. The defendant cannot simply use my name or likeness without permission. Let's try another one. Here, the defendant photographer places cameras in M's home, and without her knowledge, he watches her as she goes about her daily routine. What privacy tort? Intrusion upon seclusion. Remember, this focuses on invasion into a place of seclusion where you have a reasonable expectation of privacy. What if he then puts the video on the internet? You guessed it. This is giving publicity to private facts. Publishing to the public generally true private information about the plaintiff constitutes publicity of private facts. The final example. Suppose defendant newspaper runs a story about a serial murder on the loose. They don't have a picture of the suspect, but they do have pictures of the plaintiff, so they simply use the picture of the plaintiff in the story, implying, of course, that he is the serial murderer. What claim? Obviously false light, right? It's a false information, so it's going to be the false light claim, and because it's in a newspaper, it's going to be publicity. What other tort could it be? You should recognize right here that it's also defamation, because it will lower the reputation of the plaintiff in the community, and it's false. I hope this helped you understand both defamation and privacy. If you have any questions, feel free to email me. Thank you.